The case study that I had here was one under the old rules we were doing, a trust cloning. It was hyper urgent. The mum was very, very sick. Her husband had passed away earlier in the year. She had become very sick, and they really wanted to move the original assets not just into one clone trust, but actually 3 clone trusts, but the principle's the same. We urgently did the trust instrument cloning. It was back at the time where you had to say the instrument was basically identical, or you need to make sure that the vesting of the new trust was prior to the vesting of the current trust. So we urgently did this. The trust instrument they gave us was the electronic version. It wasn't actually signed, and the vesting date was in the schedule blank. Now, the accountant told us, look, it's absolutely 80 years. There's no question. It's 80 years. Every day of the week, it's 80 years. Assume it's 80 years and do your trust clone. So we did our trust clone. We inserted a new definition of vesting day that said 1 day prior to the date that the original trust clone the original trust vested, and went off and did the trust clone. Got it all done probably about 4 weeks before Mum passed away. Never actually got around to seeing the original trust instrument. We didn't mandate that. We had a letter saying, look, we're relying on the fact that you've told us that that's the vesting date. Mum died. We did the estate administration. Somehow the original trust instrument turned up. The original trust instrument said the vesting date is the last to die of Dad and Mum. Dad had passed away earlier in the year. Mum's passed away. So that trust clone effectively lasted about 3 months, because the way we drafted the vesting date was 1 day before the original trust vested. The original trust vested the instant Mum passed away because she was the last to die. And so that whole big exercise of doing the trust clone was completely defeated.